this program, and the Board of Trustees of UAP, and the administration is grateful to SAILS, UNESCO Madanjit Singh South Asia Foundation, and the South Asia Foundation Bangladesh chapter for choosing UAP as the place for this unique program. In this vein, I would also like to remember the contribution of our great former Vice Chancellor, National Professor Dr. Jamilur Reza Chaudhary. The UMSAILS program will foster greater understanding among the students of South Asia, as it will encourage students from different South Asian countries to exchange ideas among themselves. In my opinion, hosting this sort of lectures is extremely important for students and academic alike. This not only increases exchange of knowledge between the students, but also promotes healthy debate, which is extremely important for young minds. The University of Asia Pacific has always promoted academic debates between students and encouraged them to undertake various extracurricular activities to harness their academic knowledge with practical know-how. The UMSAILS UAP lecture is an important part of that, and I would advise our students to attend these lectures regularly so that they can increase the depth and breadth of their knowledge. I am extremely happy that someone of the stature of Professor Hoque has agreed to deliver his lecture to our young minds. I hope they will learn from his vast knowledge and try to understand the true meaning of his message. So without further ado, I will request our distinguished speaker to deliver his lecture. Thank you.
Sir, you may start.
Thank you. Honorable Acting Vice Chancellor of the University of Asia Pacific, distinguished guests, students of the university, ladies and gentlemen. I feel myself extremely privileged and honored to be able to present to you a talk on a constitutional law issue encompassing constitutionalism in South Asia. And I would like to begin by thanking the university authorities and Dr. Ishaq Siddiqui, the convener of this program, and the acting director of UMSAILS, and the University of Asia Pacific generally. So I'll be speaking about 40 to 45 minutes. It's a vast topic, largely wide. My aim here tonight is to generate questions amongst the audience, the questions of propriety, questions of ownership, with reference to our very own constitution that founded a nation called Bangladesh some around 50 years ago. So the topic that has been advertised is something different than I have designed for presentation, but the content is nowhere different. It's just some cosmetic change in the title words. So the title that I have chosen is Post-colonial Constitutionalism in South Asia. Do constitutional foundings matter? So to give you an overview of the content of today's discussion over the next 40 or 45 minutes, let me begin by saying this. I'll basically try to draw a picture of present-day constitutionalism in South Asia. I'll rely for that purposes mostly on three countries, Bangladesh, India, and Pakistan. Although by the term South Asia, I'm referring to the modern age nation states that form together the institution we call SAARC. And the analyses are based on founding constitutional values of these three nations. So the constitution that founded these nations had some values, norms. And to assess to what extent they are faithful, I mean, these nations are faithful to the high values enacted by the founding fathers of their respective nation. And that's one of the aim of this talk. And beyond these three countries, as for other South Asian nations, most of which have democratic aspirations, but not all, democratic contextualism may not be the founding goal, or democratic constitutionalism may not be their founding goal. It's a complex area because not all of us are on the same page. Then the central argument with which I conclude actually is here at the beginning. My argument is that today there is a democratic backsliding, backstabbing in South Asia generally, and the constitutionalism is at stake in every single nation. The founding constitutional values generally provide a normative framework for a post-colonial constitutional order, but they themselves do not provide a clean break from the colonial past. So the founding constitution, or any constitution of any nation for that matter, is a bridge between its constitutional past and its constitutional future. So the present constitutionalism is the bridge. And the final conclusion is most South Asian nations today have shied away from their constitutional founding values and goals. What do we mean by constitutionalism? That goes into the title. Constitutionalism is a term that's not subject to a concrete or singular definition. It's rather a concept that depends on context, on politics, on society, and the goals of a society. However, we may try to define constitutionalism. On another note, we often qualify the term constitutionalism by various other prefixes. For example, political constitutionalism, legal constitutionalism, transformative constitutionalism, abusive or autocratic constitutionalism. Now, so what do you mean by constitutionalism? To me, constitutionalism means, or it refers to, a complete political accountability of those charged with the public governance, of those in power of the people they govern. So it includes the accountability of the judiciary, as well as other two major organs of the state. And constitutionalism also means that the state shall maintain a distance from the liberty, autonomy of individuals, the citizenry as a whole. Of course, subject to the requirement of public policy and governance and the rule of law. So to have constitutionalism in a given society, there are certain preconditions. And the preconditions are like these: the rule of law, the rule of constitution itself, because the very word constitutionalism derives its root from the word constitution. So it means the rule of constitution. It means the checks and balances of state powers, independent judiciary, protection of civil and social rights, participation of the public, freedom from corruption, free and fair multi-party elections. And there might be other elements in the list. Then to give a very sketchy, very magnetic idea of South Asia as a constitutional region, as constitutional states. So here we have Bangladesh, India, Pakistan, Afghanistan, Bhutan, Maldives, Sri Lanka, and Nepal. So the region of South Asia is controversial, but for the purposes of the discourse, we take the definition of SAARC. And here, Afghanistan is the latest member of SAARC. So, as I have hinted, I'll basically focus on Bangladesh, India, Pakistan, and there are reasons. One major reason for this is our common past. So before 1947, these three countries were one and single country. So that's one reason. And of these 8 countries, we have different years of independence and different years of founding constitutions. And in case of many countries, I mean at least 3 countries, Afghanistan, Pakistan, and Nepal, you can see multiple constitutions. And it's very difficult to find out which one is the founding, which one is the basic. Say, for example, in case of Pakistan, it's a question whether its founding constitution is of 1956 or the present 1973 constitution. And if you come to Bangladesh and Pakistan, Bangladesh does not have multiple constitutions, literally, but there have been many constitutional phases and many constitutional faces or pictures or imaginations or images in Bangladesh, amended both formally and informally by democratic as well as undemocratic forces. And so in these 8 countries, Bangladesh, India, and Pakistan had a common past. Let me now go to that to cover. So before I do that, I'd like to introduce you to the age, to the time we all are living in. So this is certainly not the age of democracy. This is certainly not the age of human rights. This is an age of democratic backsliding. And it's a global phenomenon. And South Asia is very much into this phenomenon. In the last 10 years or so, many countries, European, American, East European, Asian, have slid back from democracy into either full or semi-authoritarianism. This has happened even after or despite following periodical elections. So you have election periodically on the one hand, but on the other hand, you have democratic backsliding, democratic fall. And how this happens? It happens through populism. So the leadership embraces populism. Populism is a concept in which you can say that the leader, the governors, the rulers, or the people who are in charge of governance of a country feel themselves as kind of sovereign symbols, and kind of they go into the thought of that they can do anything, and is their domain to do everything and anything for the people. And democratic backsliding happens through a systematic erosion of public conception of democracy and the rule of law. I'm not saying erosion of public trust. It's a systematic erosion of what people think or understand by democracy, by law. Say, for example, when people tend to accept a particular form of governance as the best, although by international standards, by constitution standards, that's the degradation, then that's public conception, erosion of public conception of democracy. It might happen through electoral corruption, engineering, or institutional violence. I mean, destruction of institutions of democracy. And there are three aspects. I'm not going to detail on that. Three aspects of democratic backsliding: societal, it destroys the society as a whole, democratic societal fabrics, and it destroys institutions of democracy, and it reinforces itself. I mean, the phenomenon of democratic backsliding through a process, through a package of processes. That's the processual aspect of democratic backsliding. Now, the South Asian constitutionalism. Let's begin with a bit of history to give you a proper perspective of what we expected when we emerged as sovereign, independent nations. So Bangladesh, India, and Pakistan, and some other countries in South Asia, with the exception of Bhutan and Nepal, were ruled by colonial powers. And but all countries in South Asia, by and large, wanted democracy, wanted democratic constitutionalism. And this is most evident in the founding aspirations of Bangladesh, India, and Pakistan. So before 1947, we actually were under colonial period from 1550 to 1947. And there are some overlaps between independent or Swaraj, say for example, by Mughals, and also colonial power. For example, the Portuguese are recorded to be in India since 1510. Anyway, in 1857, we had a great mutiny in India that's actually called the independence movement or independence war of the then British India as a whole. So 1857. After that, the democratic formation or democratic makeup of the colonial governance began to change. Immediately after 1857, we have 1858, the Government of India Act in 1858. So since then, the British government started to own governance in this region rather than East India Company. Then immediately after that, we have 1909, 1919, and 1935, the Government of India Act. We also have Indian Councils Act 1892, by which the legislative councils were introduced with a mixture of local leaders and colonial masters. And finally, we have the Indian Independence Act 1947 that gave birth to India and Pakistan as two separate states. As a footnote, the Government of India Act 1935 was a constitutional template on which independent nations, India and Pakistan, based their constitutional formation or building, nation building. For example, a scholar says that 75% of 1935 Act went into the Indian Constitution of 1949. On the other hand, for Bangladesh and Pakistan, the 1935 Act was the interim constitution until 1956. So the point I would like to make here by referring to the all historical data is that these nations staged a revolution, silent revolution in 1857, and thereafter there was some armed revolution or some conflict, but basically silent revolution to gain independence on the basis of aspirations of democracy, constitutionalism, and rule of law. Then let me say a few words about the state of constitutionalism in India. So in 1935, when the Government of India Act was enacted, or immediately after that, the people generally envisaged only one India for the purposes of independence. And when in 1946, the Constituent Assembly of India began its functioning, it was a constitution for India as such that was in their mind, the mind of the forefathers. However, lately, the emergence of Pakistan became conspicuous, and there was a division of Constituent Assembly of India in 1946, basically in 1947. And at that point, there was another Constituent Assembly for Pakistan, and we know the history. It was two countries in 1947. And when India adopted its constitution in 1949, it declared itself as a sovereign democratic republic. So let's simply emphasize on these words, sovereign democratic republic, and aiming at justice, liberty, equality, and fraternity, four principles for its citizens. And the constitution was based on secular values. Interestingly enough, the term secularism or the principle of secularism didn't find a place in the Indian constitution in 1949. However, there was a huge debate about the constitutional secular foundation of the Indian nation. And at the same time, the fundamentalist Hindu forces in the name of RSS was there. I'm talking about 1947 down to 1949, before the Indian constitution was enacted. And the government came up with a heavy hand on anti-democratic forces and fundamentalist Hindu protagonists. So it means they had secularism in mind. Although the term secularism, the principle of secularism, made its way into the constitution in 1973 by amending the constitution in an undemocratic way. It's an irony. Then in the founding constitution of India, it's a very interesting factor, rare constitutional leeway for the autonomy of Kashmir. So it has many states. No state of India has a constitution of its own, but Kashmir had a constitution of its own, and it had a different type of constitutional autonomy within the constitutional unity. Now, scholars allege that the secular Indian constitution has received many cuts since at least from 2015. It might be even before. And there has been an unprecedented violence to the constitutional integrity of Indian federalism. And Kashmir is an example. Now Kashmir's autonomy is done away with, and the federal power or the president's rule has been imposed. And another very important and consequential factor is Indian NRC, National Register of Citizens, which is indeed a potential case of mass denationalization in waiting. And the people who are targeted for the exclusion as citizens are minorities, are Muslims in India. So the ongoing NRC project in India has reduced the weaker sections to a notch, to nothing. And this discrimination, this persecution is based on religion. Then in India, the judiciary has been made subservient by a myriad form of ingenious interventions and threats. Indian judiciary was once credited for being the world's most powerful, innovative, and activist judiciary. But that are the heydays. Now it's one of the most subservient judiciaries in the world. And now it's a rule of racial inequality, in a sense of personal freedom. It's a diminishing of human rights and human dignity all over India. And finally, the government's current agenda is development. in India. So we can see that starting with a very high constitutional vision of democracy, or participatory constitutionalism, inclusive constitutionalism, India has now made a U-turn or made a paradigmatic shift towards autocracy. Now, Pakistan. So, very interesting once again, Pakistan began with secular vision like India. Although the creation of Pakistan and India is with reference to the two-nation theory, is based on religion. We all know that. But interestingly, the Pakistani forefathers, founding leaders, promised a secular constitutional order to its people in 1947. And history is records. Muhammad Ali Jinnah made a statement, which is now in public domain, in which he promised a secular constitutional system. However, when the 1956 Constitution was being drafted, it was never meant to be drafted in 8 years, starting from 1947. It took long 8 or 9 years to draft the Pakistani first constitution. Why? And the reason was Pakistan's, shying away from founding promise of constitutional secularism or equality between two wings of Pakistan, Bangladesh and West Pakistan, and the guarantee for the human rights of minority people. So when these things are being compromised, the people, the leaders from Bangladesh in particular, opposed and created some delays in the formation of Pakistan 1956 Constitution. However, when the 1956 Constitution was adopted or attained, it promised or it clearly adopted certain foundational values of democratic constitutionalism, parliamentary democracy, human rights, and strong form of judicial review. Yet, the very constitution was named as Islamic Constitution. The state was named as Islamic Republic of Pakistan. So it gives a non-confidence to the minorities within the territory. And Bangladeshi leaders, the representatives from the then East Pakistan, East Bengal, vehemently opposed this Islamization of Pakistan, first or founding constitution. And that was the most short-lived constitution in world history. To be honest, before it was put into effect, the constitution was suspended by military dictator. Then came, autocracy or martial law. And in 1962, Pakistan got another constitution, which was a constitution that can be termed as an internally imposed constitution. So, Bangabandhu Sheikh Mujibur Rahman himself dubbed the 1962 Constitution of Pakistan as undemocratic. So it's a very interesting term. A whole constitution can be undemocratic constitution. This is interesting. And since 1947, the Pakistan's constitutional history is a trajectory full of derelictions, full of stories of unconstitutionalism, full of breaches of constitutional fundamentals. And you will see that immediately after 1947 independence down to 1970 December, there were no general elections in Pakistan. This is unthinkable. The first elections came in 1970. In the meantime, during Ayub's regime, there was an election, but that's not democratic elections. That was engineered election. So that's the constitutional history of Pakistan. Then came the 1973 Constitution, which is a new constitution adopted, made by the elected leaders who got elected in 1973 elections. Then, the 1973 election was itself largely based on 1956 founding values: democracy, minority rights protection, strong form of judicial review, and independent judiciary. So, despite a founding constitution, so in Pakistan's case, we have got two constitutions that found Pakistan, 1956 and 1973. Democracy still remains an illusion. It's an illusory concept in Pakistan. And in the meantime, Pakistan experienced hybrid parliamentarianism. At one point, we are unsure whether Pakistan is any more parliamentary democracy or a presidential form of democracy. It was indeed, at some point, a mixture of presidentialism and parliamentarism. And in Pakistan, until today, fair and free elections remain an unachieved goal. As such, civil military autocracy or civil military intervention into politics has turned out to be a harsh reality in Pakistan. And it's a commonplace that the present government is widely believed to be a result of engineered electioneering, planned and designed by military bureaucracy. And judiciary is subservient, and minorities need protection in Pakistan. So that's the state of constitutionalism in Pakistan. Now, let me come to Bangladesh. So we got our founding constitution in 1972. This is unlike Indian constitution, unlike Pakistani constitution. We call it a revolutionary and autochthonous constitution. It emerged out of a worst massacre, was genocide in world's history. So the constitution is based on the blood of the people who sacrificed their lives for an independent nation. So it's unlike other two constitutions. And the 1972 constitution is verily an answer, a reply to unconstitutionalism, to autocracy, to absence of democracies in Pakistan, I mean, from 1947 to 1971. It's an answer to the denial of linguistic freedom of these people. And it's an answer to the denial of the right of self-determination. Let me now go straight forward to the Proclamation of Independence, which is Bangladesh's first constitution, or interim constitution, so to say. So the Proclamation of Independence governed the governance of Bangladesh, the government and citizen relationship from 26 March down to the 1972 constitutional adoption, entry into force, 16 December 1972. The Proclamation of Independence heralded three principles or three major promises for the people of Bangladesh: equality, human dignity, and justice for all. And then, before the Constitution began its journey, or the Constitution Drafting Committee started its process, on 14 January 1972 in Dhaka, Bangabandhu Sheikh Mujibur Rahman gave a speech in which he uttered these words. These are quoted verbatim from Bangabandhu's speech, translated into English in the then Daily Observer. Bangabandhu said that the aim of the new state is to establish a just society free of exploitation, to establish a society in which rule of law, respect for fundamental human rights would be ensured. So, and if we come to the Constitution, you will see the reflection of these principles in the preamble, and in a more pronounced way in the famous 4 principles of the Constitution, or 4 identity principles of the nation. I would like to call them as identity principles of the nation. And these principles are democracy, nationalism, socialism, secularism. So I'm almost about to finish, but in the meantime, I can see a very honored guest in the audience, Dr. Kamal Hussain. Let me welcome you, sir. Thank you very much for making time to be with us tonight. So Bangladesh promised to its people a transformative and democratic constitutionalism. So by transformative constitutionalism, I mean a total transformation from a ruled society to an independent society. A society in which no one will be exploited. Everyone will have his or her due. So it's a society that has been dreamed of social justice. This is transformative constitutionalism. Then the 1972 constitution, amongst the South Asian constitutions, is the most clear break from the past. And as a way of introduction, I said that no founding constitution is a clear break from the colonial past. It's a bridge. But if we consider in that term, it's definitely to some extent a breaking away from the past. So Bangladesh constitution is the most clear form of that constitution. Although it had held positive legacies, I mean, the good legacies from the past, say for example, you can say we have borrowed or we have retained, so to say, these things, not borrowed from our colonial or from our simply constitutional past. And these things are parliamentary democracy and human rights and citizens' autonomy. I mean, the independence of citizens, the sovereignty of people as such. Then breaking away from constitutionalism, the constitutionalism with which we started our journey in 1972 began in 1973 by the very second amendment to the Constitution. So we have inserted into Constitution the provisions, wide provisions for emergency, and also a blank check for preventive detention or security law. So that's unthinkable in constitutionalism. It's clearly an antithesis to constitutionalism. Then in 1974, there was a constitutional mega breakdown. So it's a constitutional failure. And it's a constitutional replacement by Fourth Amendment in the sense that it was one party, I mean, our transition to one party from multi-party democracy. Then from 1975 down to 1990, there was a complete absence of democracy. And it was military civil autocracy that ruled the country. And in 1991, we had a new beginning, return to founding values or re-embracement of democracy. So we all know that this is called democratic transition in 1991. Then in 1996, constitutionalism is in crisis, yet constitutionalism endured. It did not completely break down. Then we got a system called caretaker government system. And the purpose was to ensure free and fair elections. And under the leadership or under the caretaker government system, we had several fair and free elections. And that continued until 2007 January, when we got a military intervention into democracy in 2007. And it lasted for 2 years until 2008. It's a purely military intervention. Although, luckily, it was a civilian government that was in power. And in 2009, we have had second democratic transition since 1991. This is my own terminology. So if you recall, 1991 is the democratic transition, 2009 was another democratic transition. And it followed 2008 elections under the caretaker government system. Then in 2010, there was a judicial intervention into mega politics. What did the judiciary do? The judiciary, the appellate division of the Supreme Court, had invalidated the system of caretaker government as unconstitutional, saying that it's a government of a few, selected few, and unelected government. So it's incompatible with democracy, which is a founding value itself. However, that led to a constitutional crisis, and in 2011, the parliament took off from the constitution the caretaker government system that was introduced to the constitutional system through a consensus amongst all political parties in 1996. That was a fact. So I do personally see the 2011 abolition of caretaker government system as a form of abusive constitutionalism, because you are saying that, or the politicians are saying that the abolition of caretaker government system is to maintain democracy, is to ensure that no unelected government is in power even for a day. But in reality, it's to help oneself. Politics is to gain political benefits over political oppositions. Anyway, so that's, in my opinion, a form of abusive constitutionalism. And immediately after that, the largest constitutional crisis in Bangladesh history began. So in 2014, we had general election, but it was of low turn elections. It was a low turnover elections, and it was indeed a one-party election. There were other political parties, but as a constitutionalist, I would regard it as a one-party election. So in practice, not in law. Then in 2018, the next elections, there was a serious blow to the institution of fair and free elections itself. And it was a consequential elections. The consequence is multi-party democracy is eradicated. And today we do not have any opposition party in parliament. Maybe you have an officially declared opposition. But in reality, in practice, that's not an opposition at all, because that's a partner of the government, a party to the coalition of the government indeed. So the result is this: there is no checks and balance in the government, and the government is accountable to itself only. There is no other form of accountability. And when there is no accountability, or when there is an absolute unaccountability, then we can say that there is no rule of law or there is no democracy. That's our thesis. So informed scholars from home and abroad are calling that we now have entered a hybrid regime. It's a mixture of democracy and autocracy. It's a hybrid. Or we have a constitution without constitutionalism. So the present day constitutionalism is politically and racially exclusive. The party pluralism is hampered or is absent from the constitutional politics. And indigenous people are excluded from governance constitutionally. I mean, we do not have any constitutional recognition of the indigenous people, or we do not have them in local governance, and minorities are not well protected. And each of the four founding principles is attacked, not only today. It started from 1975. It actually started from 1974. Secularism is compromised. Religious freedom is also allegedly strained. And the worst form of, degradation, constitutional backsliding, democratic backstabbing is this: the citizens' liberty, human rights, human dignity are the victims. And the Digital Security Act epitomizes the deeper problem of constitutionalism in today's Bangladesh. and we have a new agenda. Agenda is development. So, but maybe at any cost. Today in a Bangla newspaper, there's a report in reference to another report, Global Index report by Varieties of Democracy, in short, VDEM. The report was indeed released on 11 March. So I've been reading the report since then. The report is titled Autocratization Goes Viral, and the report places Bangladesh in the list of electoral autocracy. And with reference to liberal democracy, Bangladesh is placed at 154th out of 179. And with reference to electoral democracy, the position is 138th. And for egalitarianism, the rank is 176th. And remember that we have 179 counts. And in terms of participation of the people, we rank 143rd. And very unfortunately, Bangladesh lags behind every single South Asian state except India. So we have 8 states. Bangladesh and India in this list rank on a same footage. And other 6 South Asian nations we're talking about are ahead of us. So now, conclusions. And in this conclusion, I'd like to make a very preliminary assessment of the constitutionalism positioning of these 3 countries in terms of founding values. Modern constitutionalism present day constitutionalism is, the term is misplaced here. The present day constitutionalism in South Asia shows a pattern of mixed legacies. So it's a mixture of democracy and autocracy. And constitutionalism in South Asia is still pretty much colonial in nature. The governments in South Asia, fearful about political oppositions and religious or terrorist extremisms, have resorted to the use of power like the colonial government. So there's no difference. And this style of governance undermines and diminishes human dignity and the citizen's right to be treated as equal citizens and owners of the state. So today there's a creation of unequal citizenship, or full citizenship and half citizenship. We can validly question, are we citizens full or half of the state? And most states in South Asia have today embraced authoritarian constitutionalism. Although this is a misnomer, because when you have autocracy, you don't actually have constitutionalism. However, we can fairly say that they have embraced authoritarian constitutionalism, traveling a long way away from their respective founding values of democratic, transparent, accountable, and transformative constitutionalism. Now, a little bit of conclusion on Bangladesh. Treading the developmental path is at the cost of founding goal of transformative constitutionalism. Today, we have plenty of exploitations. We have corruption. We have social injustice. We have marginalization of our own people. And there is a widening gap between the rich and the poor. And today, we also have unearned incomes in many pockets. And all these things are prohibited in the founding constitution of Bangladesh. We dreamed for a transformative constitutionalism and a society free from exploitation, based on the rule of law and human rights and dignity. So the last sentence, and this is quoted from one of my recent articles, papers, titled as the founding and making of Bangladesh's constitution. And The article has gone into a book published in this January. The book is in my hand. I'd like to take this advantage to show it to you. It's about constitutional foundings in South Asia. So it's a record of all 8 South Asian nations on constitutional foundings and the progress they have made on that account. So the last sentence is this, I quoted from that paper. Almost 50 years into the Constitution's founding, its transformative aspirations for a democracy based on the higher values of social justice, rule of law, and popular sovereignty have largely remained unfulfilled. However, I understand that this is a sad note to conclude the talk on constitutionalism in South Asia and to draw a conclusion in reference to Bangladesh. However, let's not forget about the agency of human beings, about the power of people to forge ways to transit to democracy when they need to transit to democracy, and the power of constitutional transformation or to forge a re-embracement of democracy really lies with the young people. Most of the audience members are young today. So I'd like to stop with that note and thanking you all so very much for being present in this talk. So it's a long day, you all have worked. And I also like to thank University of Asia Pacific and the UNESCO Madanjit South Asian Institute of Legal and Human Rights Studies and its acting director, Dr. Ishraq Siddiqui. I look forward to interacting with you, and you are welcome to even pose questions with reference to other states which I have not covered that much in this talk. Thank you very much.
Thank you, Professor Hoque, for that lovely lecture. I think we are extremely lucky to have very eminent guests amongst us. We have Dr. Kamal Hussain. Is the best person to give feedback on your lecture and to give us comments about what's happening to Bangladesh over the course of last 50 years. We also have amongst us Ms. Hamida Hussain as well, Barrister Sarah Hussain, Barrister Jyotirmoy Barua, Ms. Farida Begum, so all eminent people in their own fields. And so without further ado, I'd like to take questions now. So please go ahead. You can just open your mic and ask any questions you have to Professor Hoque. Anyone?
Yeah, I would like to.
Yes, Mr. Karim, please go ahead. Yes.
All right. Thank you very much, sir. I mean, Professor Ridwanul, sir, for this wonderful presentation. And I have 2 questions basically. One is that in your findings, you are talking about the transformative aspirations of the Bangladesh Constitution. But how do you see that transformative aspiration of the Bangladesh Constitution in the light of the so-called judicial innovation of the basic structure, which is developed by the judiciary? How do you find that? Is it like, is there any conflict between these two? This is my first question. And my second question would be on the issue of democratic backsliding. So how do you find the role of the judiciary in terms of, I mean, propagating or enhancing the democratic backsliding, giving the government or those politicians an opportunity to only to justify and say, this is not us, this is the decisions of the judiciary, and therefore we are amending the constitution as per the decision of the judiciary, and thereby they are also amended some other electoral rules of the country in the process. So prima facie we don't see any backsliding, but there is a backsliding, yeah. But how do you see the role of the Supreme Court in different amendments of the constitution, where they justified their position because of the democracy, but in turn they have facilitated that to the politician to do the democratic backsliding?
Thank you, Mr. Karim. Before I forget the questions, let me try to respond to your interesting questions. And those are very valid, but at the same time, complex questions in the sense that they are not susceptible to one concrete or precise answers. But with reference to the transformative constitution, I do like to see the judiciary as a partner, not as the simply passive institution with no role in the transformation of constitutionalism. But basically, by transformative constitutionalism, we mean to improve the lot of the toiling masses, the common people, who are deprived from their dues. So the wealth is not concentrated, consolidated in the hands of a selected few people or few families. So transformation in that sense, but the judiciary has a role, and I am always in favor of the inclusive role of the judiciary. So they're a partner. So let me not detail on that, but maybe through judgments and different activities, the judiciary can change the lives of people in many ways. The people who are poverty-stricken, the people who are discriminated, the people who are deprived of their dues, something like this. But when the question of the basic structure doctrine comes into that, I'd like to regard or consider the basic structure doctrine as a tool. Throughout my constitutional law career, I was in favor of the basic structure doctrine, and my only reservation is in its use. So the challenge for the judiciary is to use the basic structure doctrine principally. I mean, on the basis of principle, not principally, on the basis of principle. So we favor a principled concept of basic structure doctrine. So the question is how to ensure that the judiciary would be ethical, would be principled in applying the basic structure doctrine. So that's a political question. So how the judiciary is constituted, who are the people in the judiciary, and who is the government, or what is the government in within the broader political climate. So all are intertwined, but I think it's a constitutional technology. The whole purpose of the introduction of basic structure doctrine in Bangladesh, and the stalwart of that doctrine, the Honorable Dr. Kamal Hussein, is amongst us today. So it was introduced so that the constitutionalism cannot be compromised, so that the people in power cannot undermine democracy, cannot replace the constitution. So its purpose is to prevent constitutional breakdown, constitutional replacement. But it's unfortunate if the judiciary itself, to some extent, misuses the very tool of constitutionalism. And that actually happened in reference to the caretaker government decision. It was an unfortunate decision. And to be fair, it's I mean, if I exercise my academic freedom, apart from politics, it's a political decision. So, and the mistake the court did is that the court perhaps couldn't visualize that the politics would use the very judgment on caretaker government as a tool to implement their own agenda. So the best policy for the judiciary is not to intervene into mega politics. It's difficult to separate politics from constitution. And Supreme Court of Bangladesh, like any other Supreme Court in South Asia or in the world, for that purposes, is a political institution, and they exercise political power over constitutional political issues. But they must refrain from intervening into mega politics. So the form of government is a mega political issue. It must not be decided by the court. Thank you.
Thank you, Professor Hoque. I think we have a question from Ms. Noreen Rahim. I think she wants to hear your views on the future of upholding secularism, one of the 4 pillars of our constitution, especially when we're observing the religious hatred and events of attacking religious minorities and atheists from the last few years. So what is your view on that? I think she wants to just get to understand your view or hear your view about it.
Well, on that point, I'd like to begin by saying that, so since 1971, so it's not that, secularism wasn't debated in Bangladesh. Maybe we didn't have enough time to debate on secularism before framing the constitution. But immediately after framing the constitution, there was a debate and discourse in Bangladesh as regards secularism. So I'd like to begin by saying that there is a correlation between democracy and secularism. So if you do not have democracy, you can't have secularism. This is very obvious and visible. So we have a future for secularism in Bangladesh. I do not have doubt in that, but that depends on to what extent we are democratic. And democracy is a culture. Democracy is a culture when, for the purpose of party politics or to attain undue advantage, electoral advantage, a government compromises with reactionary forces. So, they automatically, ipso facto, come away or shy away from the secular principles. And that we can see today. Some forces are attacking on minorities in Bangladesh, but we do not see enough actions on that, either preventive actions or post-attack actions. And the reason is obvious. Is that there is a lack of political willingness. Do I want to do this right now? Something like this. So every constitution, every democracy passes through different types of tensions and during different times. And this tension is good and beneficial for the health of democracy itself. We can clearly see that we have a tension between secular principle and democratic principle. And the best example of this tension is reflected in the constitution itself. We now have a very peculiar position, although I support this position for different reasons, and we don't have enough time to elaborate on this. The position is, the coexistence of Islam as a state religion and secularism. So this is a political compromise, and it's interesting that the compromise has been inserted into the constitution by the very political party which led the country through to independence, and the party which spearheaded the concept of secularism. But anyway, I can't say that we don't have any future for secularism in Bangladesh. We have, but it all depends on democracy. Thank you.
Thank you for that. I think we have a lot of questions, and I just wanted to follow up with what you have just said regarding secularism, and you can answer this later on if you want to. I was just wondering whether time has come for us to define what secularism really is, and how do we actually try to define secularism in a country like Bangladesh and try to make it non-controversial. I think that is something which I want to hear from you as well. But we have more questions, but we have a question from Mr. Shoikat Bhomik. I think Mr. Shoikat Bhomik, one of our questions. Mr. Bhomik, do you want to ask a question? And then I'll come to Mr. Takbir Huda Shadman Khan as well. Mr. Bhomik. We can't hear you, Mr. Bhomik. You have to unmute yourself. You have to unmute yourself. We can't hear you. Okay, I think. Oh, no, we can't hear you. Sorry about that. I'm sorry about that. Mr. Huda, do you want to ask your question, please?
Thanks very much, and thanks a lot to Dr. Ridwanul Hoque for this insightful lecture. And I ask this question not only given your expertise on constitutionalism, but also tort law. So we know that there's a very real deficit in tort litigation in Bangladesh, and the one avenue through which citizens appear to have sought compensation is under Article 102(1) of the Constitution. So I just wanted to ask for your thoughts on this practice. Do you think, or do you that this is the way that our founding fathers had envisioned Article 102(1) to be used, to seek compensation whenever there is any form of rights violation? Or did they envision that to be used as an exceptional measure? And more generally, is Article 102(1) equipped to fill the vacuum that has been left by our tort deficit? Thank you.
Very briefly, Takbir, so we're talking about the Constitution. I'll not bring the whole scenario of tort into this question or this answer. I'd rather stick to the concept of constitutional law tort. And from that purposes, obviously the founding fathers inserted in the Constitution a very, very insightful, wide and pragmatic provision in Article 102(1). If you look into the very wording of the provision of the clause number 1, you'll see that, I mean, the judiciary is clearly given a power to expand constitutional remedies, any other order. So depending on the circumstances, a constitution is called an autobiography of a nation. So it develops through the ages, I mean, develop with the nation itself. And judiciary is an important partner of constitutional organs, with other constitutional organs, to help expand the constitutions. So yes, under Article 102, I mean, that can be used to fill the vacuum in the constitutional, sorry, in the tort law deficit. Say, for example, a minority group has been violated on a wide scale. Say, for example, the case of Barua people, or the people in Ramu, Cox's Bazar, some 4 or 5 years ago. And say, for example, the people very recently from Hindu community, whose houses, temples are set on fire, burnt. So they can claim some compensation from the state for its failure to protect them under Article 102. It can be used. It's a tool. It's a class action litigation. There can be class action litigation for constitutional compensation. We don't have any records in Bangladesh, nor in South Asia. But forefathers of the Constitution, the framers, thought well in advance before us by simply inserting a phrase, any other remedy. That is appropriate for the needs of current society. Thank you.
All right, now I'd like to put to you the question Mr. Afzalur Rahman has said. He asked, how do you assess the role of parliament and opposition in safeguarding the constitution of Bangladesh in the future? That is a question from Mr. Afzalur Rahman. Do you want to respond to that? How do you assess the role of parliament and opposition in safeguarding the constitution of Bangladesh?
Well, thank you. It's a brilliant question. So today we are talking about constitutionalism, but the question belongs to the field of political constitutionalism. The duty to uphold the constitution is fundamentally and primarily on elected branches of the government, on parliament and political parties. And it's very interesting. Political parties is an element of constitution. So if we talk about democracy, if we talk about parliamentary democracy, that's unthinkable without political parties. It's not simply the ruling party. All political parties are an important part of the constitution. They are they're constitutional entity. But unfortunately, we do not have enough provisions on political parties, about their role in the constitution. we simply have a definition of political party, nothing else. And the regulation of political party is done by another law, which is kind of constitutional instrument, the People's Representation Order of 1972. So yes, they have both parliament as a whole and the political opposition. And in the current constitutionalism scenario, we have opposition parties beyond parliament. So either in the parliament or beyond parliament, the political parties generally and the opposition political parties have a role to uphold the principles of constitution. The question is to what extent they're living up to the duty or promise. Thank you.
Thank you, Professor Hoque, for that. We have a question from Mr. Hoque Bhomik. He's one of our UMSAILS scholars, and he has two questions. The first question is democracy a fundamental criteria for constitutionalism? And the second question is it possible for an autocratic government to establish constitutionalism?
Another brilliant question. Yeah, and the two questions are interlinked. When we utter the word constitutionalism, so it means we have a constitution. So can there be constitutionalism under any type of constitution? My answer is no. And we heard during my presentation that there's a word, undemocratic constitution. And also there's a word, internally imposed constitution. Say, for example, in 1962, Bangladesh had a constitution when it was part of Pakistan, which was not only undemocratic, that was also imposed constitution. It was not made by the people. So the phenomenon of constitutionalism pre-requires a democratic constitution. So it cannot be simply under any constitution. So an autocratic constitution cannot give us constitutionalism. Thank you.
We have a question from Mr. Shadman Mizanur Khan. Mr. Shadman, do you want to ask him a question? I can't hear you. We can't hear you.
Sorry. Oh, good evening. I'll just skip straight to the question. My question essentially revolves around your statement regarding the caretaker government and its removal by the appellate division. So we all probably agree that the caretaker government was an effective and contextual tool in addressing the situation that we had back then, addressing the political turmoil that we were facing back then. And the Supreme Court, or any court for that matter, is regarded as the guardian of the Constitution. So following from your opinion that the appellate division caused an abuse of constitutionalism, the guardian has failed to protect what it has said, what it set out to protect. So my question is, whether do you think that the court should bring back the concept of caretaker government by issuing a suo motu rule, or should we look for, or do you have any other opinions on whether we can establish a similar framework for that might serve the same goals, or be used as a similar tool to address the political turmoil that we are facing now, the undemocratic turmoil that we are facing now? And my second question involves the secularism aspect of constitutionalism. So in the Bangladesh Italian Marble Works case, which dealt with the martial law proclamation orders, there the court re-established secularism as a fundamental democratic character of the Bangladeshi Republic. There the court intertwined secularism with a democratic nation. Over there, do you pose a different view that no, secularism does not equal democracy, or democracy does not equal secularism? These are the two questions that I have. Thank you for your time.
Thank you. With reference to your second question, let me take it first. I said that I understand secularism and democracy as parts of the same coin. So when you when you uphold the principle of secularism, what does it mean actually? And Dr. Ishraq had a tagged question with that. It means basically no discrimination among people based on religion. So if you read the Constitution very minutely, you'll have the same provision in other clauses of the Constitution, in other articles. The principle of equality, for example, and the freedom of religion, for example. So all are subject to non-discrimination. So isn't it a principle of democracy also? Yes, it is. But with reference to Dr. Ishraq's question, is it time that we defined the ambit of secularism? In the original Constitution, we had a definition of secularism that's pretty progressive definition. And yes, we can expand on that secularism, particularly now, because we have a very contradictory provision side by side secularism. Because you are saying on one hand, Islam will be the state religion, but you're saying secularism is the fundamental principle of the Constitution. Then how do you reconciliate between the two apparently conflicting provisions? Or what is the meaning of Islam being state religion? So does that impose any obligation on the state? Or what is the meaning of secularism in the Constitution? Does that impose any positive obligation, duty on the state? Or simply all negative duties, not to intervene with people's freedom of religion, or to give something to the people, say, for example, in terms of protection, okay, to the minorities. So does secularism entail a positive duty on the state to extend a very workable protection to the minority, something like this? So all are pertinent questions, philosophical and constitutional questions. Yes, we have something to do on that front. I'm sorry, I forgot your first question. Very briefly, just refer to, because you posed a long question.
I have a lot of questions. I'm sorry, Shadman.
Okay, sir, I'll reduce it into the easily identifiable material.
Quick question, there are a lot of questions. All right, you think about
what is the guardian appellative? The courts are the guardian.
Yes, I got it. No, I'm against the court's involvement into these type of mega politics. So it is unthinkable for the court to issue another motu rule to restore caretaker government. No, that's absurd. That's absurd. No.
But sir,
so it's a political question. It's a political question that's fixed politically. Thank you.
Right. I want to call Mr. Isaac Robinson. Mr. Isaac Robinson had a question. You want to ask the question?
Yeah, thank you, Dr. Hoque. This is a very radical view, and I'd like to hear your opinion on that. When you talked about backsliding, like
I can't hear you
clearly, Mr. Robinson. We can't hear you clearly.
Can you hear me now?
Better,
yes.
Much better. Yes.
Yeah, I mean, like when you are talking about backsliding, like to have a backsliding, you need a platform. And if you consider 1972 Constitution as the platform, but then within 9 months, like we have the second amendments. And what if we say like the 72 Constitution was an ideological innovation driven by individuals, and then it's very common in revolutionary circumstances that some of this ideological innovation come up. But the remaining story is like after 9 months, you have the second amendment. After 2-3 years, you have the fourth amendment, and then the military dictatorship. And that constitutionalism that you are talking about, that never existed. We have an illusion that we had an ideological innovation, but that was never accepted by the people. Like I could give you some example. Like if you look for the Operation Clean Heart after 90s, that was extremely popular, and that was basically extrajudicial killing, and that was supported by people. Like you look at the media and they talk with people, say like, oh yeah, these guys, bad guys are getting killed. You have the 2008 caretaker government, that was very popular. You have 2 military dictators. They are very
Mr.
popular.
Robinson, please ask the question. Sir, please ask the question.
My question is like, what we are talking about the backsliding, can we say that we actually never had that constitutionalism? We have an illusion of that.
Very interesting question.
Well, thank you. Well, thank you. Nothing is perfect in this world, okay? But if you look at the framing of the Constitution, its timing and the mandate that made its way to the founding moments in Bangladesh, you'll see that by then, I mean, if you apply the standards that you see globally, you can't say that it was an undemocratic constitution. And of course, in every constituent instrument or constitution, you will see some lapses, some weaknesses, some missing points. So that's not the problem of democracy as a whole. So it's a question of accommodation. It's a question of reconciliation of tensions, something like this. So because on the one hand, you have the majority people. On the other hand, you have the minority people. You have democratic forces. You have undemocratic forces. You have people who want secularism. You have people who want Islam as the state religion. So all these tensions. But when we talk about democratic backsliding, definitely we have a kind of platform, a reasonably common consensus, common understanding about democracy. So when I'm saying that for the last 10 years or 12 years or 15 years, we are on the way of democratic backsliding. I mean, so immediately before that period, so the democratic that existed, something like this. That I'm taking as a departure point, as a point of departure. Yeah, and also by measuring by the standards of democracy accepted by the international community. Thank you.
All right, we have a question from Mr. Qazi Zahid Iqbal, and he asks you, do you think Article 70 is an obstacle to constitutionalism? Do you think Article 70 is an obstacle?
Well, I do not think this is an obstruction to constitutionalism, because constitutionalism should be understood in a society-specific way. In a society-specific way, we have some other provisions like that create confusions, that create contradictions. Say, for example, the provision of the reserved seats for women. So you can argue from both angles. The reserved seats for women are either supportive of women empowerment, or they are the expression of the fact that women are weak. That's why you need protection, something like this. So anyway, the question could be whether we need Article 70 right now. And once again, I would say that yes, we still need that, because we are lagging behind from the accepted principles of constitutionalism or democracy. So the reason why Article 70 was introduced in 1970 was to make democracy stable. And if you look into the pages of Bangabandhu's Atmajibani, I mean biography, you'll see that he clearly mentions the abuse of floor crossing provision in the Pakistani time. So there was a reason, and the reason was a higher reason, the ground for democracy. But the reality is that we have abused that provision, that standard, Article 70. And probably there were 3 amendments to Article 70 from 1970 down to 2011. And recently, by 15th Amendment, Article 70 has been restored back to the 1972 Constitution. And if you carefully read through the lines of Article 70, actually you will see that it's not that incompatible with the freedom of expression. A member of parliament has to lose his or her seat in parliament for going against the decision of the political party that gave him or her the ticket. But our politics has gone to such an extent that we do not even think of uttering a single word, not only against the party, but also against the leader of the party. So with or without Article 70, I mean, we don't have a different picture from what we have now. Thank you.
So we have a question from our student in Nepal, and she has a similar question to our former head of department, Mohammad Asaduzzaman. And the question goes, do you think that democracy in political parties is a conditioned precedent to have a democratic government in Bangladesh? And how can we ensure democracy in our political parties? Interesting questions.
Yes, I do subscribe to your view that democracy, internal party democracy, is a condition precedent to democracy in society overall, as a whole. But unfortunately, we do not have any theory, any formula to ensure party democracy or democracy within a political party. So you can see that, I mean, we have rules and laws to regulate political parties or elections, election funding or other things. And the main purpose of those rules is to ensure democracy and transparency in party. But politics or party politics is a culture, So we are culturally lagging behind in terms of running political parties in line with democratic principles or establishing democracy within political parties. And maybe we need some more time, and maybe it's because of the heavy family influence or destiny influence in political parties. But definitely, unless and until we can ensure a minimum level of democracy within each and every political party, commensurate with constitutional standards, principle of non-discrimination, for example, principle of women participation, for example, we cannot, optimally ensure democracy in society, in the polity itself. Thank you. It has been a very, very insightful and interesting question.
We have a question from our BOT, Board of Trustees, Mr. Qayyum Reza Chaudhary. Sir, do you want to ask a question? You raised your hand.
Yes, I just wanted to tell him and inform him that the political parties have a constitution, and we abide by that constitution. And constitution is very, very democratic. If you go through the constitution of this party, you'll find total. Unfortunately, this is not carried out. What's there? Who unfortunately it is not, just. The constitution of every political party is very democratic. The constitution, very, very. Dr. Kamal can, satisfy you by saying this, but it's not practiced, unfortunately. Where we go wrong, democracy is not practiced in the political parties because of nature that people power from the central, and this is carried rightly. Have you understood? That's what I was trying to say. That's where the constitution that submitted, returns are submitted to the chief election commissioner, and they certify this particular party has a constitution, and the constitution is pretty, what should I say? But I want to thank you.
Thank you. We couldn't hear you the last points, but I think you have covered well. Yes, we understand that political parties have their own constitution, but maybe not all of them are constitutional in nature. I mean, very strong, democratically framed constitutional manifestos or party constitutions. They try to live up to the requirements of the law, but there are problems also with reference to their party bylaws or constitutions. But it's an issue. It's an issue, and we also need to focus much more than we usually do on political parties, their role, their constitutional obligations. So that should be made accountable to the people as well. So we talk about accountability of the ruling party only. So why not the accountability of the main opposition, or accountability of a political party who is not even within parliament, or not even has not even won a single seat in parliament, something like this. Thank you.
I think I'll ask you the one last question. I think we have run out of
Dr.
time.
Hoque, I mean, Mr. Faiz Ahmed sent a message, question.
Yeah. So I was just going to ask you that in a pandemic situation like now, what role the Constitution could play to make the state and the government accountable? It's a very relatable question.
Yeah, this is relatable. I mean, Constitution doesn't know any pandemic. Constitution is for all seasons. So Constitution intends to make the government accountable, whether it's a pandemic or not. But however, this is an extremely important question, because whenever there's a pandemic like the present COVID pandemic now, we have got a kind of emergency ipso facto. So people have developed an understanding that probably government can dictate us to do this, not to do this at any time it desires. Or government can impose lockdown for 365 days, something like this. And this type of understanding has developed from the very ground of pandemic. So it means Constitution has a role, actually. Since the Constitution didn't foresee this type of pandemic, and there's a debate whether an emergency can be imposed on the ground of pandemic or COVID-19 type of situation in Bangladesh. My simple answer, maybe I'm wrong, is that Constitution has a strong role to make the government accountable during a pandemic, and the requirements are democratic requirements. The action they are taking must be transparent, must be proportionate. I mean, say for example, lockdown. So when the government is imposing lockdown without properly taking care of the downtrodden people, the people who are the daily wage earners, then there is a automatic violation of constitutional obligation on the part of the government, because the state, the Constitution is aspiring for a society free of exploitation, or in which a society in which social justice would be ensured. So it's the government's duty to prevent people from being exploited because of pandemic, something like this. And on the other hand, we see that, I mean, the pandemic situation is being regulated by issuing different types of notifications, notices, declarations. There is no consistency in this sort of regulation. So that's not compatible with the rule of law. And we don't see enough roles to be played by the cabinet as a whole and parliament as a whole. For example, the parliament is in session during this pandemic, but for the last 1 year, parliament hasn't enacted a single law on the regulation of pandemic, on the welfare of the people during pandemic. Not a single law, except one, by which the courts have been empowered to go online. That's the only one exception. Otherwise, parliament or the executive government as a whole is failing us by the standards of constitution during this pandemic. Thank you.
Thank you for your answers. I think we still have a lot of questions left, but I think we have run out of time. I think I'll finish by probably getting some kind of feedback or comment from Dr. Kamal Hussain. Sir, can you hear us? I can see Mrs. Hamida Hussain online. I was just wondering whether you could give us a small feedback on what we have heard.
No, I very much welcome the fact that the discussion has begun. 50 years after the Constitution was adopted, there's been a discussion in which I can see quite a lot of distinguished lawyers, professors, and practicing lawyers participating in the discussion. Questions that have been raised are really pertinent, and the fact that expectations are not being met. The Constitution, like any other law, and Constitution is a fundamental law, so there are much more basic expectations from the Constitution. That it will provide good governance, it will provide protection of rights, it will provide for a kind of freedom of expression and discussion, and so on. Now, I think when these kind of discussions are being held, you should ask, what are the expectations that people have? Because the Constitution is still with us. Happily, constitutions have had, in other developing countries have had a short life. Technically, at least, our Constitution is still alive, and some amendments that were forced upon it have also been held by the court to be invalid, so that the normative principles are there. Normative principles in a way reflect the expectations from the Constitution. But whether these expectations are fulfilled or not, it's for all of you citizens. It is, when you say that power belongs to the people and citizens are those who are the owners of power, this means that it is citizens who have to ensure that what is expected from the Constitution is indeed delivered by the Constitution. But elections are very critically important, because elected people are expected to be responsive to what the people want. Now, question is, if you ask, do our elections in our country and in other countries, where you might have all the trappings of a free election, but do they give to people the kind of representation that they want? Do the representatives deliver what people want? Are they really, in that sense, accountable? Now, how you achieve this is, we have had, say, from 47, if you look, it's probably half a century. But in that period, there are so many disappointments, so many expectations that remain unfulfilled. I would like to see, we can have meetings and so on. Let us say, what do we expect from the Constitution? What do people expect from the Constitution? And why are these expectations not fulfilled? Are they fulfilled? If not fulfilled, why not fulfilled? These questions must be focused, and we should all be participating. I'm very glad that the process of at least discussing the Constitution has begun, and that scholars have participated in it. The principal speaker has taken a lot of time and effort in doing it. It is important that it's not sort of, come out with definitive judgments. This has failed, this has failed. Question is expectations. What were the expectations? To what extent those expectations have been fulfilled? To what extent have those expectations not been fulfilled? Now, I can go on for a long time, but I hope that we will have a series of discussions on these questions. What are your expectations from the Constitution? What are your expectations from Parliament? What are your expectations from law enforcers? What are your expectations from those who do policy planning and so on? Now, why those expectations? Are they fulfilled or not fulfilled? This every citizen must address. Because don't forget that it is citizens who the Constitution recognizes are those who are vested with power. There is no monarchy here. There is no sort of all-powerful executive, which is expected to define those expectations and fulfill those expectations. Now, sometimes what happens is that ordinary people's expectations remain unfulfilled because there are powerful people who can get away with not fulfilling those expectations. So, accountability is important. How can accountability be enforced? How can accountability be addressed through institutions? Now, we have courts, we have various commissions and so on. Question is, do these commissions and courts succeed in ensuring accountability, in ensuring performance of the obligations in the Constitution? I hope we can get an opportunity to discuss these at length and throughout the length and breadth of Bangladesh, and by not only lawyers, but professors and people in all sort of walks of life who have every citizen, as I say, vested with ownership of power in the state. So you must say, what do I expect? What do I expect in terms of education, in terms of what do I expect in terms of equality, and so on. Wherever there is a deficiency, notice, speak out and say how, and put also across how this can be redressed. Now, I think I'll stop there because no one can go on very long. Thank you.
Thank you so much, sir. I want to thank, it's really an honor and privilege that we are today listening to a lecture from Professor Dr. Hoque, and we're getting feedback from the person who has drafted our constitution, or the chairman of the Constitution Drafting Committee. I think we're extremely lucky. I want to thank everyone on behalf of SAILS and the Department of Law and Human Rights at the University of Asia Pacific for joining this lecture, joining this seminar. I mean, lecture has become like a seminar. So I want to thank all of you. And I think our lecture would be successful if we could think and if we could debate about some of the most important issues that Professor Hoque has brought about. I think the more we debate, the more we question, the more we try to answer or try to get the answer to what is actually happening in our country, or try to get the examples of other countries who are having similar problems. I think when we try to do that, or when we try to get to that point, these kind of lectures and seminars will be successful. So I want to thank all of you for attending today's lecture, and we're going to keep on having these lectures more or less from every week from next month. So I want to thank all of you, and I hope all of you have a pleasant evening. Thank you. With that, I finish the program.
Thank you all.
Thank you. Thank you.
Thank you.
Thank you.